First, I will repeat the words said by Michal before, and I'm quite sure that also my successors will repeat the same words, how we respect the project and especially the work of dear János, who really did a masterpiece editing our contributions in a book which got such a good review as we heard from Professor Rakushi this morning. And the second thing is that I would like to excuse my dear colleague Vasilka, who is not with us. As János explained you in the morning session, she's in Stockholm in another conference, and therefore I will use this chance not to stress my presentation on international field of law, because she's an international lawyer and I'm a private lawyer, and I will put my attention to the private law questions of right to safe drinking water. Okay, I need my presentation.
Would you be so kind as to try it again? Okay.
Yeah, great. So, however, I will start with some international aspects, and since 2010, several countries, especially from Africa and Asia, of course, from Africa and Asia, updated their legal frameworks to reflect water and sanitation and as human rights. The number of these countries is higher and higher, and also in academic literature, for example, the scholar Sereno put the right to water as a subjective human right with direct applicability. But we all know that it's quite simple to put something as a declaration in a legal document, and the real problem is how to fulfill the goal of putting a value in the legal rule, and even if this legal rule is in the highest document in the legal hierarchy, so in the Constitution, or even more in the International Pact of Human Rights or something like this. And we have quite the same discussion regarding the change of Constitution of Republic of Slovenia. In 2000, after 2010, the first discussions in Slovenia began about amending constitution with a right to safe drinking water, and someone could expect that such amendment should be adopted with acclamation, but it was not like this. Of course, there are some opponents putting this right in the catalog of human rights in the Constitution. The strongest argument in this discussion was that there is no need. Slovenia has developed quite a huge catalog of human rights, and of course we can also put the right to safe drinking water as part of other basic rights, for example, of the health environment and some other human rights. However, the constitution was amended in 2016, and I think that Slovenia is one of the rare European countries that went in this way and put the right of to drinking water as a special independent right in its constitution. The constitutional provision has four pieces, and I put some stress on basic provisions. So the right to drinking water is right of everyone, so is the common right. The second very important legal consequence of this basic rule is that the water is a public good, so the individuals could not impose the property right on the water. This is not new in Slovenian legal system. The same regulation was in force even before. Then the water should not be a market commodity, and the local communities shall provide the drinking water to inhabitants, to citizens, on a non-profit basis. These are four basic pillars of this constitution provision, and I would now touch the implementation, implementation problem of this rule. The basic is the new Environmental Protection Act. It was adopted in 2002, this year, 2022. And in field of drinking water, the new law just repeat the provision of the older one. And surprisingly, in comparison with some other commodities, the drinking water is very, very poorly regulated in the Basic Act. We have just a very, very general provision that drinking water supply is mandatory local economic public service, and local communities have a competence to issue bylaw regulating the supply of drinking water in details. So we don't have a single act regulating the supply of drinking water, but in Slovenia that means 264 different local communities, what means also very different conditions for the regulation of supply with drinking water. Also, the Water Act from 2002 contains some basic provision about the water supply, and this one provides that water supply shall have priority over use of water for other purposes. In this abstract view, quite clean regulation, but we say the evil is in the details. And this year, in summer 2022, there was a severe drought in large part of Slovenia, which affected the water sources for the drinking water supply, and in some places caused a severe shortage of drinking water. Especially in the Adriatic part of Slovenia, city of Koper, Izola, and Piran. It's about 80,000 inhabitants in these two cities. But of course, during the summer, in time of all three cities are on the coast, and of course, number of tourists increase the population of these three towns. And especially in city of Koper, which is also an industrial city, the shortage of drinking water was a serious problem. And the local community started thinking how to solve the problem, and one of idea was to dry the Ljubljana riverbed. The Ljubljana river is the source of drinking water for this region, and the mayor of Koper city proposed to dry the Ljubljana riverbed to enlarge the capacity of drinking water supply for the local supply. On the other hand, fishermen and some environmental organizations strongly opposed the announced measure, because the dry of the river could cause very harmful ecological damage on fishes and other living creatures who living in the water. And it's really difficult to solve this conflict. The supply of drinking water on one hand, and the living animals and living creatures as an environmental damage on the other hand. Thanks God, it was no necessity. The rain, thanks God, came and solved the problem. So nobody needs to adopt this very, very sensitive decision. But it was really this question: who is incompetent to adopt this decision? To dry the river, to save the water supply, the water supply. So we will see what will happen again. We expect the extreme water, the extreme weather situations also in also next years. So the second question is the question that the water supply must, the public, that everyone has right to be connected to the water supply. And we have question of illegal buildings. In our legal regulation for connection of building to the water supply, the building must the building permission must be issued, and without building permission, it's forbidden to connect the building to the water supply. But on the other hand, we have some marginal people, communities with shelters, without any legal building permission, and especially the Roma population. So, in one local community, some Roma people, the name of this family is Hudorovic. This is a very common name for the Roma people in Slovenia. And of course, some Roma people is very good finding a good advocate, and they go to the European Court of Human Rights in Strasbourg. The Roma community, of course, illegal buildings, no direct water supply, and they started with argument that their basic human rights are breached. And of course, they fulfilled the application to the European Court of Human Rights in 2014. The municipality installed a water tank in this community, and this water tank was regularly filled with fresh water by the firefighters. So it's not also these Roma people were not without water even in the summer. So the European Court of Human Justice considered that the authorities in this case ensured that applicants had the access to safe drinking water through this concrete measure, and and rejected the application of this family. Another case which is quite interesting is a question of water connection in case that some people technically could not be connected to the public water line system. For example, in this case, the decree on drinking water, this is bylaw to the Water Act, stipulates that the public water supply must be provided in the area of settlement with 50 or more permanent residents and with a settlement density greater than 5% permanent residents per hectare. And of course, we have also smaller communities as this one, and one of these communities in municipality of Ribnica. This is a small town in the central of Slovenia. They're trying to get the water supply for 20-30 years. And in this community, it's 11 houses and 25 people, aged from 6 to 80. And these people, they made an application to ombudsman. And ombudsman, in his reaction to the application, started the conversation with the local community. And of course, the local community had number of excuses why this part of community couldn't get the connection. And in his opinion, even in this case, that the community has not fulfilled the conditions by law, the ombudsman put in his decision that municipality in this case violated the principle of good governance, and that the petition is justified and suggests to solve this problem. I will skip the next one, not to be a little bit too long, and I will start another issue. This is suspension of supply of drinking water due to non-payment. It's also a very sensitive question. The Constitutional Court of Slovenia very early in 1998 ruled that the question of the interpretation of water supply do not that this interruption is a permissible measure due to non-payment. But be very careful. This is from 1998, and from this year, I think some legal values a little bit changed. We have in Slovenia quite new Electricity Supply Act, and in field of electricity supply, also the European Union adopted a directive about an electricity supply, also put in the center of this directive so-called vulnerable customers. This is the people who's not in position to pay the electricity, and also in this case the legal rules of the directive demanded the protection of such consumers. It's not allowed to interrupt the electricity supply even in case of non-payment. And of course, Slovenia, as a good member of the EU, harmonized its national legislation with this rule and put these rules to protect the vulnerable consumers in its legal order. On the other hand, we have the right to drinking water as a constitutional right, but no special rules providing the protection of consumers. And our suggestion was, from Vasilka and me in our paper was that the law in Slovenia should change, and the same mechanism of protection of vulnerable consumer should be also imposed for the drinking water. And I'm quite glad that one of our reviewer this proposal found as a very good proposal. But we also have different praxis. For example, also another case by ombudsman in city of Ljubljana, the capital. The ombudsman got a letter from a single mother with 2 children asking for intervention due to, by her opinion, unjustified disconnection of water. The local company from Ljubljana explained this interruption, and also the ombudsman saw that this interruption was justified. The lady didn't pay the bills for the water. However, ombudsman made a letter to this local company, described that this young mother is in a very tough position, and especially the children, how they really need the water. And after this letter by the ombudsman, the local provider, the company, changed the mind and connect this family to the water supply again, and gave the young lady the opportunity to pay the old debt in the installments. And of course, the local company reported to the ombudsman about this case, and ombudsman assessed this conduct of the company as an example of a good practice. So the company was not obliged to do this, but for justification, this is the practice. It's quite interesting. Slovenia, as I said, has right to drinking water as a constitutional right, but in implementation we have huge problems. Thank you very much for your attention.